Hello, my friends. Welcome back. Once again, I want to, show my appreciation for all the folks out there that were commenting and texting me and emailing me. I love hearing from everybody. And as always, just feel free to hit me up in the comments here, and I always do my best to respond to everybody. So just be nice or a little bit nice. All right, I'll make sure I respond. Okay. So today we're going to talk about Jon Gruden and his crazy lawsuit. This one individual is going up against a multi-billion-dollar entity called the NFL and its supreme leader, Roger Goodell. All right, so this guy's going after everybody, and it's such an interesting lawsuit. And like I always say, the goal of this show, right, is that you're going to learn a lot about civil procedure, about contract law, arbitration issues, and all these like complicated legal stuff. All right. And you're going to learn about it like as I kind of walk you through this funny lawsuit and this funny like dispute between Jon Goodell and the NFL. And speaking of dispute, do you ever go to Sunset Cliffs, Mateo? I know it's kind of far from here. Hang out there. Beautiful area, right? And like at the beach, right? They do like these free yoga classes. So in Sunset Cliffs here in San Diego, what a funny dispute. The residents got so annoyed with this lady that was giving out free yoga classes right there on the beach, like overlooking the ocean here in San Diego, that they passed an ordinance banning it, saying if there's ever more than 4 people doing an activity together that looks like it's somewhat of a quasi business, they're going to kick them out. And all these people are upset because it's like, oh my God, you got like 1,000 homeless people that can hang out there, no problem. But then you get this lady that's doing these free yoga classes. You don't look like the type of guy that would do yoga on the beach anyway. Zeke is probably there. Like, no wonder we didn't see you yesterday, Zeke. Were you there at the beach doing yoga? Anyhow, so what do you think? Fair, unfair? But there's a certain point. Imagine they, you live there and you want to go to the beach and there's always people after a yoga class, then there's a Pilates class. Then you got Zeke doing a freaking spin class or something, right?
Oh, boo-hoo! Let me play a sad song for you on the world's smallest violin.
Yeah, you know what? To be honest, it doesn't bother me either. It's not that bad to where I think they would need an ordinance to start kicking off and like having the police. Imagine all these people doing yoga, and then the police come to break it up. Stop doing cat cow and stop doing this freaking yoga move or something. All right. What else is interesting? Scarlett Johansson, right? So she has a wonderful voice, and a lot of people would call it a very sexy voice. I'm sure Zeke would agree here. So ChatGPT wanted to use her voice in kind of like all of these like services that they provide. So she said no. So what did ChatGPT just do? They use her voice. They claim it was someone else, which probably was someone that sounds exactly like her. There is you have a copyright to your voice, and there is it's called a likeness and a voice, how you look, your appearance, things that you say or talk, do this and that. They are properly copyrighted. So you can't just go and mimic somebody's voice for commercial purposes. Do you know what I'm saying? Like if it's like an SNL skit or like a quick, like you're making fun of Donald Trump and you mimic his voice in terms of like some sort of political speech or kind of like a funny commentary about him, that would be okay to mimic his speech a little bit. But to like fully take on someone's voice and use it on ChatGPT, that would be a no-no. So right away, ChatGPT said, okay, we'll stop. We didn't mean to mimic her voice. That was a coincidence of all things. I'll tell you, it's not a coincidence, right? What do you think? No chance. You know whose voice they did not want? Joe Samo. It's like, dude, you know it. I just Google my name. My voice is everywhere. I'll give it to you. No, we want someone sexy like Scarlett Johansson, not Joe Samo. All right, speaking of sexy, let's talk about Jon Gruden. What do you say? All right, get to the point. Let's do it. This is such an awesome case, and you're gonna love hearing about this. So it was the 2021 season, and by the way, for better or worse, I'm a big Raiders fan, so I kind of know more about this case than normal cases. So Jon Gruden was coaching the Raiders for a few years, and in 2021, he gets fired over these leaked emails. And now comes kind of like, how did all this happen? So that year in 2021, there was all these complaints about a whole different team, the Washington Redskins. Back then they were called the Washington Redskins, or maybe that was right when they had that interim name. What was the interim name? The Washington Football Club or something, right? Or the Washington Football Team. And now they're called the Commanders. So the NFL was investigating this team, and because there was a lot of female employees saying we were getting sexually harassed. It turns out they were correct. They were being sexually harassed. There was things like when they were the cheerleaders, they would ask them to pose topless, and they would do things like when there was like a swimsuit, cover photos or something, and then the team was like secretly recording all of it, things like that. Pretty crazy stuff, you would say, right? So the NFL was investigating all this because all these female employees were complaining. And then during the investigation, they find, and over 500,000 emails were looked over, hundreds of witnesses were testified, things like this. So the only thing that came out about it was a few emails got leaked that Jon Gruden had sent to some employees for the Washington Redskins 10 years before. What a crazy coincidence, right? And these emails were really bad. I mean, they were, I don't know about the word really, but they were bad. Let's go over some of them that was leaked. Like, so Jon Gruden would say things like, I don't know why the NFL is forcing the Rams to, pick up this queer player. Now, you would think on the face of it, when I first read it, I thought that was not cool, right? And I still think it's not cool. But what he was saying, he wasn't saying, I don't think openly gay people should play for the NFL. What he was saying was that the NFL eventually came down on the Rams because they wanted somebody to draft him. You know what I'm saying? Because it would look bad if nobody drafted him out of college. And so they kind of started pressuring the Rams. So his thing in that email from 10 years back when he wasn't even in the NFL. He was like a broadcaster at ESPN or something. So, he was just saying, I don't think it's right that they were forcing a team to draft this player. Other things that he called Goodell things like, I'll just say the other F word. You know what I'm talking about? A homophobic slur, the other F word, okay? And the P word. All right. I feel like if I say them out loud, YouTube is just going to like bury everything. So, so he would call Goodell all of these things, like in these email correspondences back and forth. And it was funny because supposedly the NFL got all of this in the summer of 2021, but they didn't leak it until the middle of the Raiders season. Freaking screwed up that season for the Raiders. So in October of that year is when all these emails came out. So when they did come out, there was a public outcry to have John Goodell removed as the head coach of the Raiders. And sure enough, he gets fired, or better yet, he was asked to resign. It's the same thing as fired, isn't it? Right? Yeah. So he resigns from being head coach because he was told either resign or we're going to have to fire you. Like, you pick one. That's what the owner of the Raiders went and told him. So Jon Gruden decided to resign. And that was October of 2021. And within 1 month, this one is kind of fast. Within 1 month, he files this lawsuit against the NFL. So November of 2021. Now, my favorite quote here in this lawsuit. In contrast to the formalities of the Washington football team investigations, and what he meant by, he was saying how secret it was and how tight the information was and how nothing was being leaked to the media about that investigation of the Washington football team. Defendants, the NFL's treatment of Gruden was a Soviet-style character assassination. That's pretty cool. Now, this is one of the things. If the guy wants to prove he's not racist, right, and that he doesn't make fun of other people and things like that, I think the last thing you want to do is piss off the Russians. Do you know what I'm saying? Like I would have picked other terms to put in my lawsuit, but nonetheless, his whole point is this. The investigation had nothing to do with him. They were investigating the Washington Redskins football team, and that's it. That's what the investigation was about. And all of a sudden, instead of saying what happened in that investigation, which was really bad, what they did. And I was only talking about some of the things that was going on in the Washington Redskins facilities. He, instead of, information coming out about that or some sort of punishment for that, the only thing they did was they leaked a couple of emails about Jon Gruden, and then he got fired. It's kind of like, my analogy to this is, somewhere in Texas, they do like, there's like a triple homicide investigation. And then after all of this is said and done, the only thing they come up with is Mateo owns parking spot fees. Little Texan over here, Mateo. And that's the only thing they come up with. So they were doing a homicide investigation, and then they go after some guy for outstanding parking fines. You with me? So this is what the lawsuit is all about. Okay. And so this was filed in November of 2021. Now, out of the gates, is it out of the gates or out of the gate? Yeah, out of the gate. All right. So right out of the gate, okay, the lawsuit happens in 2021. The NFL files a motion to compel arbitration. Now comes a kind of like, I'll explain some contract law to you. So he files the lawsuit. It turns out when NFL players and coaches and other staff members, every contract they sign, they also sign that they will abide by the collective bargaining agreement between the players and the staff and the NFL. So that is a very complicated kind of agreement, and it's always negotiated and things like that. And in that agreement, there is a provision that states if the parties have a dispute, they have to go to an arbitrator. Now, and then the arbitrator makes a decision, and then the NFL can appeal that decision to another arbitrator. And guess who that arbitrator is? Roger Goodell, or somebody that Roger Goodell handpicks. Now, that's pretty bad, okay? And so Jon Gruden does not want to go to arbitration, because if he has to do that, then he's going to, his theory is that, well, I might as well just give up now. Because if I have to go to arbitration where the final arbitrator, the one that makes the big decision, here it is, I'll just read it from the collective bargaining agreement. The commissioner, that's Roger Goodell, shall have full, complete, and final jurisdiction and authority to arbitrate any dispute involving a member in the league or any players or employees in the members, blah, blah, blah. God, how did they agree to that? So the final arbitrator is the guy you're suing, Roger Goodell. Get this. That is the dispute. That is the only dispute that has been adjudicated, and it's not even fully adjudicated yet. That's the only dispute is, are we going to go to arbitration or are we going to go to court? Now, court is better because you go to court, there's, supposedly you'll get a jury, and the jury is not paid by the NFL. They're not NFL employees, right? They're not the commissioner. You'll get a judge who's not beholden to the NFL. And so the theory is we get a better shot in a courtroom suing the NFL than we do going to an arbitration where Roger Goodell, the commissioner, is the arbitrator. Clearly, like I said, Jon Gruden does not want to go to arbitration. As Mateo's pointing out, Jon Gruden signed a 10-year contract to coach the Raiders and got $100 million. Now, he didn't even win one playoff game. He didn't even go to one playoff game, and he got $100 million, So, yes, he definitely did get a good contract. But in that contract, like I'm saying here, there is this provision that if there's a dispute with the NFL, then you have to go to arbitration. So now comes the dispute over that. The NFL files that motion to compel arbitration, and then they go to court. The first thing that the court had to decide is whether or not that arbitration provision is enforceable. This happens in a lot of cases. And for a lot of employees, they don't even know it. When they get hired onto a company, they sign an arbitration agreement. Okay. And then if there's a dispute, like some sort of employment dispute, they claim, they were wrongfully terminated or something. They can't just sue the employer in court. They have to go to arbitration. Now, then there's this theory about this financial incentive that arbitrators are more in favor of big companies because the arbitrators get paid by how many arbitrations they get, whereas the judge does not get paid by how many cases he or she gets. He just gets paid a salary, and that's the deal. So there is definitely a financial incentive to rule in favor of big companies in arbitration. Now, the arbitrators, for their defense, they'd say, oh, but we take ethical training classes and we're good people and we go by the law. We don't go by, business decisions and things like that. Okay. But that is a big fear, that there is this financial incentive and that arbitration, favors kind of the big company. Here, it especially favors the big company, darn it, because the final arbitrator is the NFL. That is like ludicrous. All right. So the trial court judge ruled that the arbitration agreement is not enforceable. And he said it's not enforceable because what's called unconscionable. Now, there is a theory in law, in contract law, that if a contract is so bad and there's provisions that are so bad, okay, then the court will elect not to enforce it. All right. Now, the words so bad are, they've been litigated forever. I say so bad. Now let me explain what the deal is. For the arbitration clause to be thrown out in this particular case, a judge has to find two things that they have to find. One is called the procedural, and that is that the parties, one party was so big and they had a take it or leave it contract, and the other party so small compared to the big party, and that, they didn't have like any negotiation power. That's one. And then the second thing they have to show is the substantive. So in addition to the procedural unfairness, there has to be a substantive unfairness. Now, with regular employees, you work at, let's say someone who works at a restaurant or something, and then they want to go to arbitration. There's certainly no, the employee of a big company has absolutely no power to change the whole like contract terms. Okay. It's like a take it or leave it. Do you want this job or not? So there's always procedural unconscionability or procedural unconscionability, but the courts have ruled in that circumstance, it's not substantively unfair when an employee has to go to arbitration, because what I said about the arbitrators are ethical, they're good people. And in those cases, they don't go, it's not like the employer is the arbitrator. In those cases, they go to a third party arbitration, usually called like American Arbitration Association, or another company called JAMS, and there's some other ones too. So those cases, the courts always rule in favor of the employer, saying there's procedural unconscionability, but not substantive. In this case with Roger Goodell, the trial court judge ruled that there was procedural unconscionability. The NFL is so big, Jon Gruden is so small compared to the big NFL, and it was a take it or leave it in terms of those contract provisions. So there's procedural unconscionability. And then the trial court judge ruled, and you need both procedural unconscionability and substantive, okay? For those, finally, the contract is so bad. The trial court judge also ruled that it was substantively unfair that the head arbitrator is Roger Goodell. All right, cool. So that was the trial court judgment. Is it over?
Nothing is over! Nothing!
Damn it. The NFL filed an appeal. All right. And so now we get so it goes from the trial court. Now it's funny because the NFL did not lose the case. They only lost the motion to compel arbitration. And now you'll learn a little procedural rule here. You can appeal when you file a motion to compel arbitration and the big company loses. That is automatically appealable. Like, so you could appeal right there. You don't have to do the whole case, lose, and then appeal. You could appeal it like immediately. And that's what the NFL did. So they appealed that, and they go to the Nevada Supreme Court. The lawsuit's going on in Nevada because the Raiders had moved, to my chagrin, from Oakland to Las Vegas. All right. So anyway, so the lawsuit's going on in Nevada. The Nevada Supreme Court then takes up that decision. About 2 years later, they finally come up with a opinion here. So this is the ruling from the Nevada Supreme Court. You had 3 judges decide it, and here we go. 2 of them ruled in favor of the NFL, and 1 ruled in favor of Jon Gruden. So therefore, the NFL won the appeal. All right. And now I'm going to break that down for you. So the NFL wins the appeal. And the reasoning goes like this. The appellate court looks at this and says, well, okay, we agree that if the contract is unconscionable, then we will rule that that the contract is not enforceable. Okay, and then the appellate court like goes through all the circumstances. Remember what I said? You need two things. You need the procedural, and then you need substantive unfairness to get an unconscionable contract. The appellate court ruled there was no procedural unconscionability. Why? Because what did you say? How much did he get? $100 million. This is Jon Gruden. He's won a Super Bowl. He's been a coach. Then he was on ESPN. Then he became a head coach again, and for two different teams. And he's a big shot, right? So if anything, he had the opportunity to negotiate the contract. Now he probably wasn't going to win, but he had the opportunity to negotiate all of that. Meaning, like I don't think he would have gotten the NFL to disagree or change their terms. But what they're saying is he was a sophisticated party. He's not like some dude that just works at some restaurant, first job at a high school or something. This is a very sophisticated party here. He signs $100 million contract and very favorable. He negotiated how much money he was going to get. He was negotiated, the terms and the benefits and all that jazz. So it was certainly not a take it or leave it contract. You would take it anyway, right? Even if it was a take it or leave it contract, I would too. Okay, but it was not a take it or leave it contract, darn it. So the Nevada Supreme Court, these three, ruled that there was no procedural unconscionability. Now the next point is if there's substantive. It doesn't really matter if it was substantively unfair or not, because you need both of those. You need procedural and you need substantive. By the way, even if it's a player making the minimum amount, that player would probably not win the procedural. Let me tell you why. Because that contract, the agreement that says that Roger Goodell is the ultimate authority, that is by virtue of the collective bargaining agreement. So that was negotiated between the NFL Players Association and the NFL. So they did have a lot of bargaining power, and they had a lot of benefits that went in favor of the players and things like that. So even if it's one player that got, that has a dispute in the NFL, it's likely here, especially the Nevada Supreme Court would say, even that player doesn't have procedural unconscionability because it was negotiated fairly. Okay. So here the Nevada Supreme Court says this was procedurally fair. Okay. And that's it. That's all they need. Like I said, to be unconscionable, you need two things, the procedural and the substantive. But just for the heck of it, the Supreme Court in Nevada, they kind of they don't even say that it was substantively unfair. They're like, yeah, Roger Goodell is the final authority, but he's not that bad of a guy. They're kind of saying that he's not that bad of a guy. And he has, in some circumstances, when he was like directly involved, he would recuse himself and have another, like he has the authority to then appoint a different arbitrator. So still, he's not that bad. And if he does make a decision that's horrible, there is law that says you could appeal, although it's very hard to appeal an arbitrator's decision. If it's so bad, then it's possible you could appeal it. This is the Nevada Supreme Court saying this. So therefore, the contract is not unconscionable. We will enforce the contract. The NFL wins. So now Jon Gruden has to go to arbitration to do his lawsuit. He can't go to a court of law. Is it over?
Nothing is over! Nothing!
Dang it. Jon Gruden said he's going to appeal that. Now, there's two levels of appeal here. He's going to appeal it because there was only 3 justices that heard it. So he's going to ask for an en banc decision. Now, en banc means instead of 3 judges, let's get all of the Supreme Court of Nevada, all the judges involved, and have them decide this. They could decide not to do it that way. And then his appeal, at least in the state of Nevada, will be over. But that's still not over. Then he could appeal to a federal court, and then a federal court could decide it. And if he loses, or whichever party loses in the federal court, they could appeal through the federal system. So we are 2.5 years into this lawsuit. Okay, we're 2.5 years into this lawsuit, and how much has been done? Nothing, right? Nothing has been done. Nothing's been done. We can't even decide. All we're trying to decide in 2.5 years. This is why a lot of people, when they come to me, they're like, "Well, how long is this case going to take?" And I say the following. I say, "Oh, I should next time I do this. Next time my phone goes on, let's just answer it, and then just have the whole phone call. Just have like we'll breach all the attorney-client privileges, just like Michael Cohen in the Donald Trump trial. We'll just breach all of that, and we'll have it right here, and I'll just have the conversation going. What do you say? Yeah or nay? It'll be good content. It'll be good content. I'll get disbarred, but I'll get some views and likes. So we gotta weigh that. We gotta weigh that. Okay. So yeah, 2.5 years. We haven't even decided who is going to decide this dispute. All we've decided is that it's gonna be the NFL, but that is still on appeal. Ultimately, they will decide the substance, but that's after all of this is said and done. You know, whether it's the arbitrator or whether it's a court of law. I don't think what the NFL did was illegal or a breach of contract, because okay, fine, they singled out this guy, and what they did, it was worse than scapegoat. It was like a diversion. They didn't want the whole Redskins organization to go down, so they created a diversion, and they just singled out Jon Gruden, right? So fine, they discriminated against Jon Gruden, but they didn't discriminate against him for any sort of what's called a protected class. It wasn't like if they said, okay, let's leak all emails of, you know, this particular race or this particular religion, or this, you know, if it was or this particular nationality, you know, if it was something like that, then it would be what's called a protected class. Then it would be illegal. But them singling out Jon Gruden to divert all of the attention from the Washington Redskins organization to Jon Gruden, I don't see it as some sort of illegal discrimination. Now, it could be that they interfered with the contract between him and the Raiders, so he's got maybe a shot there. But I don't think it's enough, in my opinion. However, I'm not going to decide the case. You know, it's going to be Roger Goodell that's going to decide the case, or someone he appoints. I have a feeling just for public, eventually they'll give him a few $1 million just to shut up. That's what they'll do. Because if they rule against him and Roger Goodell is the arbitrator, then the next collective bargaining agreement, the players and staff members will say, we have to change that. That's going to be a big deal. I would love to hear what you think, folks. I'll be here next week, and keep the comments coming. I love hearing from all of you.